Welcome to K&L Gates Working Wise podcast series. My name is Laura Scully, and I am an associate in the Newark office of the firm's Labor, Employment, and Workplace Safety Practice Area. In this podcast, I will discuss some recent key anti-harassment measures legislated in New York State and New York City. Notably, non-employees are now protected against sexual harassment under the New York State human rights law. Non-employees are defined to include contractors, subcontractors, vendors, consultants, or other persons providing services under a contract in the workplace, as well as employees of such individuals. Under this amendment, an employer will be held liable for the sexual harassment of non-employees where the employer or its agents knew or should have known that the non-employee was subjected to sexual harassment in the workplace, and the employer failed to take immediate corrective action. Agreements settling claims involving sexual harassment now cannot prohibit disclosure of the facts and circumstances underlying the sexual harassment claims, unless confidentiality is the complainant's preference. The complainant must be given 21 days to consider the non-disclosure condition. If after the 21 days the condition is the complainant's preference, the preference needs to be memorialized in an agreement signed by all parties. Thereafter, the complainant must have at least 7 days to revoke the agreement, and the agreement may not become effective until the 7 days have passed. Contracts also cannot contain clauses requiring arbitration to resolve sexual harassment claims as a condition of enforcement of the contract or obtaining remedies under the contract. This restriction, though, may be limited to the extent the Federal Arbitration Act is considered to preempt it. Additionally, effective October 9, 2018, New York State employers will need to comply with certain anti-harassment training and policy requirements. Employers must provide employees a written policy and establish annual training on anti-harassment. The New York State Department of Labor and the New York State Division of Human Rights are to develop and make available a model policy and training. Employers can use the official models or their own customized policy and training, provided that they are at least as protective as the official models. The required policy on anti-harassment must have the following features. 1. Prohibit sexual harassment consistent with officially issued guidance and provide examples of prohibited conduct that would constitute unlawful sexual harassment. 2. Include information concerning the federal and state statutory provisions concerning sexual harassment and remedies available to victims of sexual harassment and a statement that there may be applicable local laws. 3. Include a standard complaint form. 4. Include a procedure for the timely and confidential investigation of complaints and ensure due process for all parties. 5. Inform employees of their rights of redress and all available forums for adjudicating sexual harassment complaints administratively and judicially. 6. Clearly state that sexual harassment is considered a form of employee misconduct and that sanctions will be enforced against individuals engaging in sexual harassment and against supervisory and managerial personnel who knowingly allow such behavior to continue. And lastly, 7, clearly state that retaliation against individuals who complain of sexual harassment or who testify or assist in any proceeding under the law is unlawful. The required annual training on anti-harassment must be interactive and include the following: an explanation of sexual harassment consistent with guidance issued by the New York State Department of Labor and New York State Division of Human Rights. 2. Examples of conduct that would constitute unlawful sexual harassment. 3. Information concerning the federal and state statutory provisions concerning sexual harassment and remedies available to victims of sexual harassment. And lastly, 4. Information concerning employees' rights of redress and all available forums for adjudicating complaints. In addition to New York State, New York City also recently passed legislation aimed at combating harassment. Among other things, effective September 6, 2018, city employers must display an official anti-sexual harassment rights and responsibilities poster in English and Spanish. At the time of employees' hire, an official information sheet on sexual harassment must also be provided. The City Commission will develop and make the poster and information sheet available on its website. Moreover, effective April 1, 2019, New York City employers will need to provide annual anti-sexual harassment interactive training within 90 days of initial hire for employees who work more than 80 hours in a calendar year. The training needs to have the following features. 1. An explanation of sexual harassment as a form of unlawful discrimination under local law. 2. A statement that sexual harassment is also a form of unlawful discrimination under state and federal law. 3. A description of what sexual harassment is using examples. 4. Any internal complaint process available to employees through their employer to address sexual harassment claims. 5. The complaint process available through the New York City Commission on Human Rights, the New York State Division of Human Rights, and the EEOC, including contact information. 6. The prohibition of retaliation and examples thereof. 7. Information concerning bystander intervention, including but not limited to any resources that explain how to engage in bystander intervention. And lastly, 8. The specific responsibilities of supervisory and managerial employees in the prevention of sexual harassment and retaliation, and measures that such employees may take to appropriately address sexual harassment complaints. Employers need to keep a record of all trainings, including signed employee acknowledgments, which may be electronic, and the records need to be kept for at least 3 years. The City Commission is to develop a model training that employers can use, but employers need to inform employees of any internal complaint process to address sexual harassment claims. We hope that you enjoyed this episode of K&L Gates Working Wise podcast series. More episodes in our series can be found at klgateshub.com. You can learn more about our labor and employment, workplace, and safety practice on our main website, klgates.com. Thank you for joining us.